Hi, my name is Nadine Udorovic. I'm one of the partners here at Nichols Family Lawyers, and thank you for coming back today to listen to our YouTube channel. I'm joined by my associate Camilla Kaufman. We are a family law specialist firm with offices here in the Melbourne CBD and regional offices in Geelong.
Thanks for having me, Nadine. So today we'll be looking at the recent amendments to the Family Law Act, which came into effect on the 10th of June 2025. Family violence has wide-ranging effects on not just the immediate safety of individuals, but also the long-term welfare and financial position of the family. These amendments to the Family Law Act ensure that property settlement outcomes are truly reflective of that reality, as they outline that family violence must be considered in all financial matters now. For family violence to be relevant in a property settlement, there must be a clear connection between the abusive behaviour and the party's ongoing needs and circumstances. In other words, the court focuses on how the violence has affected or is likely to affect the individual's financial situation and caregiving responsibilities.
Unfortunately, family violence remains a widespread issue, both in society and within family law proceedings. According to the Federal Circuit and Family Court of Australia's most recent annual report, 83% of matters lodged in court allege that one partner has experienced family violence, and 77% of matters allege that a child has been exposed to or has experienced family violence. So the rates are significantly high. Examples of behaviours that may constitute family violence include physical assault, including sexual assault or other sexually abusive conduct, stalking or persistent harassment, repeated insulting or belittling remarks, deliberate damage or destruction of property, intentional harm or killing of an animal, unlawfully restricting the freedom of a family member or their relatives or children, economic or financial abuse, interfering with a family member's ability to maintain relationships with family, friends, or cultural connections.
The 1997 matter of Kennan and Kennan is regularly referred to as a leading case which explored the relevance of family violence in property settlements. This type of claim seemingly opened the doors for victims to argue violence was applicable in their property proceedings and has frequently been relied upon by parties seeking to demonstrate that family violence hindered their financial contributions to the relationship. So in this case, the wife claimed that she should receive an additional percentage or a further percentage of the asset pool due to the assault and battery inflicted on her throughout the relationship. The court found that the violent conduct suffered by Mrs. Kennan was a relevant factor in the context of assessing contributions made to the property by each party. The test established in the case of Kennan requires each party to receive an adjustment in his or her favour in the determination of property interests because of violence. There are a few elements that must be present for this to be established. Firstly, one party demonstrated violent conduct towards the other party. Secondly, the conduct has a discernible impact on the other party. The contributions of the affected party were made substantially more difficult due to the violent conduct.
So in this case, the court made it clear that a party is not eligible for an adjustment solely based on being a victim survivor of serious domestic violence. Instead, there must be evidence demonstrating that the violence had a substantial impact on their capacity to contribute financially to the relationship. This narrow view was taken due to concerns about floodgates being opened for cases of family violence. However, it confines its applicability to a limited number of cases and has made the Kennan decision one that is regularly criticised, especially given there is no longer a concern for such floodgates as the prevalence of family violence is so prevalent in our community today. The legislative changes made in June 2025 to the Family Law Act seem to codify the principles laid down in Kennan and later cases. So under the current law, family violence can also be relevant to the assessment of a Section 75(2) factor, and family violence may be relevant to both the assessment of contributions and Section 75(2) factors.
Since June this year, the new Section 79 subsection 4 CA and Section 90 SM subsection 4 CA requires that in the assessment of contributions, the court must examine the effect of any family violence to which one party to the marriage has subjected or exposed the other party to on the ability of a party to the marriage to make the kind of contributions referred to in those subsections. It seems likely that the amendments will not change the position under the case law, but rather draw more parties' attention to the possible relevance of family violence in their own circumstances and will look to the effect of family violence and whether it increases or reduces their property settlement entitlements.
And that's right, and I think we're certainly seeing a lot more of that coming through our caseload at the moment. So when assessing future needs, a party who has experienced severe family violence may face ongoing psychological impacts such as post-traumatic stress disorder or even physical impacts which may limit their ability to earn an income or provide for themselves or their children. And under Section 75, subsection 5A, the court is obliged to consider the effects of any family violence on the victim's current and future circumstances. The court may also take into account the costs of ongoing counselling related to the family violence experience, and we've certainly had a few cases recently where we've had to look at that assessment. It's important to remember that typically evidence such as a report from a treating psychologist or counsellor outlining the trauma and its effects will be necessary to support these claims. This ensures the court has a clear understanding of how the family violence has impacted the party's ability to work, earn income, care for children, or support their financial future.
The courts take family violence very seriously when determining property settlements. If you have experienced family violence, it is important when you feel safe and comfortable to bring it to the attention of your lawyer or the court so its impact can be fully considered. At Nichols Family Lawyers, we have extensive experience advising and supporting parties navigating the intersection of property settlements and family violence. If you are going through a separation and require guidance regarding property settlements or family violence matters, we encourage you to contact us.
Thank you for listening.
Thank you.